Okay, today is December 21st, Friday, 2012. This is Julio Zamora at 1385 El Camino Way, Los Banos, California. I was born on September 7th, 1940. This is a workman comp case against Safeway. I was injured on 3/21/2009. This is my final statement for workman's comp hearing. Short statement for the court, real short. Okay, today is Tuesday, December 18, 2012. On December 1st, 2010, I received a notice of offer of work, which they held up for 2 months, followed with a Q&A report saying I can do my customary duties, and that I have a permanent disability, and that I'm allowed prescription drug, and that they're going to take 15% out because I have a permanent disability. On December 3rd, 2010, I went to work. On the 5th day of work, I was flat out sent home because I received a notice of offer of work on December 1st, 2010. On 3/21/2009, I was sent to see the company doctor, and I ended up seeing Nancy Perdillo, who takes drug and alcohol tests. There wasn't any doctors present, and I wasn't sent to the hospital, and no x-rays or anything else was done on 3/21/2009. I had a follow-up, and the following day, and I was on light duty since 3/21/2009. And I haven't been paid every week or every 2 weeks since 4/17/2009, and it's 2012, the third Christmas. And I should also note the fact that the data machine in the driver's room, which is separate from the onboard automatic recording device, it doesn't have a time card. It doesn't do anything. Okay, when we run out of miles wherever we are, and we go back and we clock out on the data machine in the driver's room, which is separate from the onboard automatic recording device. It doesn't have a time card. It doesn't have anything. It doesn't do anything. And it doesn't record the difference in miles when you run out of miles, wherever you run out at. It doesn't record the miles, and sometimes they pay the delay, and sometimes they don't. And you have to log out of the tractor when they pick you up. And I should note, I haven't been paid going on 10 years, me and 400 other drivers. And I should also note there's drivers there, I guess, with almost 20 years or better that haven't been paid also. So the data machine in the driver's room doesn't do anything. Yet we're required to clock in at 10:30 in the morning when we're already on duty according to the federal government DOT regulation, which we're under their wing, under the federal government's wing, the Department of Transportation. We're already on duty when we arrive to work. Okay, and that's it. I'll continue this with another tape. Okay, today is Friday, December 7th. It's 9 o'clock in the morning. Julio Zamora, statement for the court. On December 7th, 2010, I had a notice offer of work. They took 15%, whatever it is, and didn't keep me working. They just flat out sent me home. On December 17, 2010, received a notice from the union attorney, Local 439 in Stockton, California, that I was discharged on December 16, 2010. They emailed it or faxed to James Williams, Transportation Manager, Tracy Distribution Center in Tracy, California, that the discharge was denied and all disciplinary action against me was to be denied, and to submit all proof and documents, photos, etc. by December 25th, that I'm guilty, false accusations, etc., etc. They didn't do so within the time limits, null and void, final and binding. I should have been returned to work like 1,500 other Teamsters in Local 439 in Stockton, California. It wasn't done. And James Williams, the transportation manager, is responsible because he was notified on December 17, 2010 that the discharge was denied. Okay, so, and then I had a notice of offer of work, like I said before, but on top of that, I filed for unemployment, and the response was that they're in conflict of liability. Conflict of liability, which means that I had a return to work, full duty, and it wasn't honored. So the notice of offer of work wasn't honored. Conflict of liability, I should be working, wasn't honored. The denial of the discharge and all evidence and documents to be submitted by December 25th, 2010 wasn't done, and I wasn't returned to work. Again, I'm repeating myself as I know. Okay, so we'll go on from there. That was 2010. So in 2011, an administrative judge, or 2012, administrative judge suggested to put me back to work. Adam Stewart asked me how long I could work for. I had a notice of offer of work that hadn't been enforced, and guaranteed for 1 year. 10 o'clock, I believe it was at 10 o'clock, Eureka Run, 14 hours a day, bid, overnighter. It wasn't done. They didn't put me back to work, and they didn't give me the bid that I requested for, that I sent registered mail to the Safeway Insurance Company, private insurance. And James Williams, the transportation manager, didn't honor it. And it was signed and agreed upon and deemed accepted, if not responded within 20 days, which I wasn't able to do so on December 7, 2010, because I was sent home flat out on the 5th day. Okay, so again, that's 3 times. I wasn't sent home, I wasn't put back to work. And it's Christmas. Each time it's Christmas. This is the 3rd Christmas, and today is December 7th, 2012. Okay? In 2012, I received a letter from Morales or somebody in Arizona, a claim adjuster supervisor, that I had a notice of offer of work, and if I could please send in the notice of offer of work that I received on December 1st, 2010, that they held up, agreed upon on October 13th, I believe it was, with Workmen's Comp, on agreement. Okay? And by them not honoring it, they're in violation of 132A. Now, I stand to be corrected on that, but my understanding, they're in violation of 132A, and they didn't honor it. Okay, so he sent me a letter or something in 2012, and the attorney sent me a letter to report to work. I reported to work, and Mike Sadler denied it. He said, you better see your attorney. I went to the union. They didn't do anything about it. And James Williams, the transportation manager, I don't know if he knew or what, or if he just ignored it. But again, I wasn't put back to work. Okay, so that's where that stands. And I should also know that I haven't had any medical benefits or anything that's been denied since since 4/17/2009, when I filed for unemployment. They're in conflict of liability. They denied me medical treatment. Disability payments are supposed to pay me every 2 weeks, and they never done so. And this is 2012, and he sent me a letter that I'm going to get paid every 2 weeks. They haven't done so. And also, they took 15% out, which left me $175 a week I'm supposed to receive every 2 weeks. It wasn't done. And I wasn't put back to work. And I have no medical benefits, and according to the QME report that I took on October 13th, I believe it was, in 2010, that I could do my customary duties that's attached to the notice of offer of work, and that I'm allowed prescription drugs. Also on FMLA, I was not to be denied any medical treatment, which also was denied. And they also took my lifetime medical insurance away that I paid for in 2002, which is separate from the Health and Welfare Fund. It's an RSVP. And they haven't paid nothing. Not in 2009. They kept taking me off work, putting me back on, not paying me my pension, not paying me back paying benefits, and I had a full release to go back to work, and it wasn't honored, and I couldn't receive any medical attention, let alone prescription drugs. According to the QME report on October 13, 2010, etc. So to this is 2012, and I'm still unable to receive any medical treatment or any prescription drug whatsoever. I have no medical insurance or no medical coverage since 4/17/2009. In 2012, I received another conflict of liability from the unemployment office, and I sent them all documents, and they don't have a right to decide anything or whatever it is. That's my understanding according to the document that I have, and that was ignored. Here it is going to be Christmas, and I should be working. And I have no medical coverage for my family or myself. And I haven't been paid every 2 weeks according to the Workman's Comp, according to the letter that Safeway Insurance Company sent me, and they haven't paid me every 2 weeks. They pay me once a year when they feel like it or whatever, plus they take 15% out, and they didn't honor the notice of offer of work that I'm guaranteed 1 year of work. Which in due respect, I asked the attorney that I be retired in 2013 on my birthday, automatic retirement, whether I like it or not, to be retired automatically in the personnel department to be informed. With all back pay and benefits from December 7, 2010 at 14 hours a day because it's a 24-hour operation, okay? And it's 7 days a week, okay? And anybody that works below me, according to seniority, I'm to be paid for that day. So every day that somebody works below me and I have 200 employees underneath me, I should get paid for that day, according to the contract, an agreement made with Safeway and the local union 439 in Stockton, California. And I should also note for the record that we're instructed to follow the Department of Transportation regulation, company policy, and union contract. And I should also note that we're under the DOT, the federal government, 24 hours a day, we're under their wing. And I should also note for the record that the onboard automatic recording device was put in the tractors so that 400 drivers and myself are unable to falsify anything. Their intent in installing those onboard automatic recording devices for no driver anywhere is to be able to falsify anything. It's tamper proof. And that's underneath the regulation of 395.15 in the interpretation, and if the Judge Bill wishes to look it up. And he also can get a copy of the contract, or I have a copy of the contract, and if he wishes to see it, where it says, if not within 10 days, it's null and void, final and binding. Null and void and final and binding. Now, I should also note, labor law, the state law states on Section 8 that you are required to prove your accusations. To prove it beyond a reasonable doubt under state law. And they haven't done so under the union contract, and so they're in violation of labor law, they're in violation of Workman's Comp, and they're also in violation of company policy and, like I just said before, union contracts. So that's the end of that, and I request a court order that I be paid from December 7, 2010 at 14 hours a day, according to the document that I received from Safeway Insurance Company, that I have an offer of work which they didn't honor, and I put down 14 hours a day, Eureka Run start time at 10 o'clock. And it wasn't accepted. So it's James Williams, the transportation manager, his responsibility to put me back to work if I don't receive the grievance that was filed within 10 days. Null and void final binding, and it wasn't done so. So on those grounds and the fact that double standards, which I invoke, life is not fair to be considered by Judge Grill. End of story. This is Julio Zamora, Friday, December 7th, 9:14 in the morning. And I should note that I have got a treating physician, acupuncture, and agreed to treat me. I was unable to get Dr. Yip, which I need a doctor for my pinched nerve. And I should also note for the record that the PR2 report did not reflect the occupational report that was made out by Los Banos Memorial Hospital, that I went in there for left leg pain, and I had a low back. And I also got a second opinion, which was not included in the PR2 report. So they just completely left it out. And I should note that when I gave them the MRI for Dr. Hubby, and they responded that Dr. Hubby said that it was a sprain. And I don't know about the knee. I don't recall ever complaining about my knee, but if that's what they said, that's what they said. There's nothing I can do about that. The fact is, my point being is that Dr. Hubby is not the one that saw me on the first day of injury. And on the first day of injury, I don't remember ever seeing an occupational report made out, and I signed it. And I should note there was 2 reports made out on 4/17 when they made out the PR2 report. I was there at 1 o'clock in the afternoon, and he made a PR2 report, I guess at midnight or something, but I was there twice on 4/17. My wife and I don't remember being there twice, but if he says he took it, he took it. I'm not about to question the doctor about what he says and he doesn't say. All I'm stating is the fact that on one report, it states I'm not sure that it's an occupational injury, and he left out Los Banos occupational report. And going back to what I said, the note was sent to Dr. Hubby. Is this a sprain or is the low back industrial injury related? The note should have been sent to Nancy Perdillo on 3/21/2009, who I saw when I first got injured. She's a drug and alcohol technician who takes tests to see if you're on drugs or alcohol when you get hurt. I did not see a doctor on 3/21/2009, and the letter that they sent to Dr. Hubby or the company doctor is incorrect. I should also note that for the record. So if there's any question about that, you could check with Nancy Perdillo and ask her if she made an occupational report out, and if she said that it was a sprain. I received the wrong diagnosis on 3/21/2009, and I should be returned to work immediately with all back pay and benefits, and my lifetime medical to be restored with automatic retirement on my birthday next year so that I don't lose the lifetime medical. And if they don't honor the notice of offer of work, then I request that Safeway replace the lifetime medical that I have of RSVP, okay, which covers medical, prescription, eyeglasses, hearing, and dental. And I got that from my wife and 2 kids until they're 26 years old. So I need that replaced. And I need that placed as soon as possible because I wasn't fired on December 7th, 2010. And I didn't falsify anything. And the fact is that the dispatcher took the time from the data machine in the driver's room and changed my time on my logs on the automatic onboard recording device from 10:30 to 11:15, and he wasn't supposed to do that, I should say, okay? He was in violation of the Department of Transportation of the federal government, who installed those machines with the intent for truck drivers, the 400 at Safeway, and myself unable to falsify anything, tamper proof. So I lost 45 minutes on December 6, 2010, and I lost a day's pay on December 7, 2010 because he took my trip sheet or my time card, whatever you want to call it, from December 7, 2010. He must have thrown it in the garbage because I didn't get paid for that day and I was there a half a day. So I wasn't fired and I didn't falsify anything. They're false accusations and they didn't prove or establish that I was guilty beyond a reasonable doubt by December 25th, 2010, according to the discharge being denied on December 17, 2010. And I was not put back to work according to the contract, like 1,500 other Teamsters in Tracy, California. Okay? James Williams, the transportation manager, did not fulfill his responsibility. Okay? And why he didn't put me back to work is a question that needs to be asked. Okay? And why didn't he establish beyond a reasonable doubt that I was guilty? The question needs to be asked, and why am I not working? And this is December 7, 2010, 2012. And so this is the third Christmas. And I need that 1 year to get my daughter to UC Merced University of Merced in Merced, California, 1 more year. So it only needs 1 more year to finish, to get her BA degree in biology or whatever her major is. But it's biology, a chemist. So I need that 1 year. And I need my lifetime medical. I can only get it if I'm returned to work. Otherwise, I lose it and Safeway needs to replace it. There's no reason I should not be working. And if there is, James Williams, a transportation manager in Tracy, California Distribution Center, needs to explain why I am not working and why am I denied all medical benefits and medical treatment from 4/17/2009. And the notation, and like I said, I invoke double standards. Life is not fair. Okay, for the record. And the notation. Okay, today is Thursday, December 13, 2012, and it's 8:15 in the morning. And me and my wife and I were having breakfast this morning. We were discussing the issues about what's going on. The first issue we were discussing was the fact that James Williams, the transportation manager in Tracy, California, is responsible for the transportation department. Okay, and the discharge was denied and he should have put me back to work, as we all know that, because of the fact that he didn't produce any evidence by December 25th or after. He didn't respond within 10 days, 20 days, or 30 days, and he violated the time limits, null and void, final and binding. He didn't prove anything. And he also violated labor law, state law, because he didn't prove his case beyond a reasonable doubt that I was guilty. He didn't produce anything. And two, we discussed the fact that the dispatcher falsified my logs. There's no doubt about that, because we're under the federal government Department of Transportation for 24 hours. We're under their wing. Three, I mentioned that they're in violation of company policy due to the fact that I followed all the regulations that we're instructed to follow, myself and 400 other drivers, to follow DOT regulation. It's under the contract and company policy, which means we're under the federal government for 24 hours. Now, what company policy has to do with the federal government, I have no idea. And why do we have two time clocks? I mean, why are we required to log in, punch in on a data machine in a driver's room when we're already on duty when we report to work according to the federal government, the Department of Transportation Regulation 395.15? Now, we're instructed to follow those, and that's what I did. And I was already on duty, but he's saying whatever he's saying. But in any event, I'm innocent. And the fact that I lost a day's pay in 45 minutes when he altered my logs on the onboard automatic recording device. Okay, so he's working and I'm not. So that's the bottom line. Two, I went to Workmen's Conference Settlement Conference. Okay? Spoke to the judge, told them that they're in conflict of liability, they don't have a right to decide anything, and the fact that I've been denied every benefits, whatever, they denied me and didn't pay me every week or every 2 weeks, period. Okay, end of story. He suggested to them, the reason I'm saying that, because my wife reminded me at breakfast of the fact that Adam Stewart did say that the attorney was on the phone with Safeway. And he asked me how long I could work for. And I had a notice of offer of work backed up by a QME report that I took on October 13, 2010, somewhere around there. And he said I could do my customary work. It was attached to the notice of offer of work, good for 1 year, plus they took out 15% because I have a permanent disability. And it was deemed accepted even if I didn't turn it in within 20 days. It was deemed accepted. So they should have put me back to work. I'm on call, waiting for a telegram or a phone call to report to work at 10 o'clock in the morning. Eureka run overnighter, and they owe me for 7 days a week at 14 hours a day because of the fact that the notice of offer of work says that work available. Well, there's work available according to seniority. I have almost 200 drivers underneath me. Well, so that takes care of that. And the fact, the important thing, the point I'm trying to make here is the fact that they're in contempt of court. They're in contempt of court. They were supposed to, he was on the phone with Safeway, and the administrative judge suggested, or whatever he said, however he said it, because I wasn't in the room, told him to put me back to work because he was on the phone with Safeway. And Adam Stewart asked me how long I could work for, and my wife was there as a witness. Now, and they didn't do that. They sent me to the lunchroom and sent me home. My understanding is that they're in contempt of court. James Williams, a transportation manager, a distribution center in Tracy, California, is in contempt of court and has been in contempt of court because he didn't put me back to work like he's supposed to. On December 17, 2010, and then in 2011 or 2012 when we had a settlement conference. He didn't do it again then, and he didn't do it again when the supervisor of the private insurance, Morales or something like that, sent me a letter to please fill it out and send it in, the notice of offer of work. And I sent it registered mail, and my attorney sent me a letter saying to report to work. I did report to work, and it was denied. And the union said, well, we don't know anything about it. It was also denied. And Mike Sadler was the one. So, they're in contempt of court. They denied me to go to work. They're violation of 132A, and they haven't proved anything beyond a reasonable doubt, and they're in violation of state law, labor law. Okay? So, they're in violation of the contract, and like I said before, they're in violation of their own company policy for the fact that Mike Sadler posted that thing to attempt to falsify documents when it isn't possible, not for myself, not for 400 truck drivers, or anywhere in the United States, period. Those machines were installed, or have the companies installed those machines by the federal government, the Department of Transportation, so that no driver in the United States is able to falsify, that's their intent, to falsify any document or any logs, which is their time card they get paid by, to falsify or anything else because the onboard automatic recording device is tamper-proof, according to 395.15. So that's my point, okay? So there was no falsification because no driver can. So Mike Sadler violated his own company policy by stating, because you punch in late, and you can't punch in late because you're already on duty. And we don't follow company policy because we're under the federal government for 24 hours a day. We're under their wing. So when we get to work, we're on duty to the federal government. We have to follow all the regulations and rules. So I don't know how they figured that I punched in late on a time call, time clock or data machine in the driver's room, which is separate from the onboard automatic recording device. And if you look under Regulation 395.15, it doesn't mention one thing about a data machine in the driver's room. It doesn't mention it. All it talks about is the onboard automatic recording device, period, end of story. Now, so I'm stating that Mike Sadler violated his own policy and standards. He didn't follow them. And for him to post that up there, I don't know what to say about that. Other than that, if any driver's been fired because of that document, they were falsely fired. It's not true. They didn't falsify anything. They can't. It's impossible. And they weren't late. It's impossible. Okay? Because that's the regulation, and we're instructed to follow it, and we do. But Mike Sadler didn't follow his own company policy by firing people. Okay? That's not possible. The machine is tamper-proof. You can't falsify anything, not by a time clock that has no time card and doesn't record anything. Okay? It doesn't do anything. Okay? So we're under the DOT or the federal government on the onboard automatic recording device 24 hours a day, and all you got to do is check the regulation and company policy and a union contract. So that being said, he needs to explain why. Why did he post that and when it's not true? To back up my statement, all you have to do is look at the regulation and look at the notice that he put on the board. And he also violated the no attendance policy, no fault attendance policy, company policy, that if you're late or whatever, and I don't know how they figure that, because we're under the DOT for 24 hours, that you get a verbal warning. But if that's what they say, that's what they say, that's fine. But I do agree with the company. If you have a time card and you have to punch in the driver's room on the time clock, and if you do come in late or something, you should get points and a possibility of getting fired. But if you alter your time card, you should get fired. You should get fired. Now, the dispatcher altered my automatic onboard recording device, the logs, and he didn't get fired. But they do have a rule that the supervisors can change the time or sign the time card that has been changed on the employee. But he doesn't have permission from the Department of Transportation, the federal government, to alter those laws. You can't make a company policy going against Department of Transportation, DOT, and at the same time turn around and say that you're on company policy. It's not possible. Okay? Company policy, you follow company policy. Now you turn around and you say, well, okay, if you punch in late even though you're on duty, you falsified logs. That's not possible. If the federal government says one thing and the company says another thing, who are we going to follow? Well, the company says follow DOT, the federal government. The contract says follow the federal government. Now this guy comes along, Mike Sadler, says, no, you don't follow the federal government. Right? I'm right about this. All you got to do is look at the regulation. You're on duty, tamper-proof, period. It doesn't say anything about you will follow DOT and company policy. It doesn't say that in the contract, and it doesn't say in the company policy. What it does say, no fault attendance policy. Now, it's true you have to follow what's on the bulletin board. That's fine. But you got to be correct about that. And why the union didn't take a position on that, I don't know. But I'm innocent. And they need to pay me the back pay. That's it. So I have a witness. I have the regulation. I have labor law. And I have contractual procedure. And they didn't complete step 1 and step 2, null and void final binding. End of story. They need to put me back to work, which I'm waiting here since December 7, 2010, for a registered mail or a phone call to report to work. That was our discussion at the breakfast table this morning, and I gotta say, this is not good. This is a third Christmas. So if anybody needs to be disciplined, I don't know who it is, but it's not me. I'm innocent. So that's up to corporate to decide what's what and who's who in the city zoo, because it's not me. I'm a good driver and I'm a good worker and I'm a good employee. So I'm not going to sit down and lay down and let them tromp on me. It's not going to happen. And my wife mentioned to me the fact that Adam Stewart said that we were stubborn. She said we. And my wife told him, I didn't hear him. My wife stood up and said he's only standing up for his rights. So now the question comes down, do I have any rights? So, am I allowed to stand up for my rights, which is being denied? I should be working. That guy's working and I'm not. And I'm innocent. And I didn't do anything wrong. And I didn't punch in late on no time clock, because there's no time card for that time clock, and you don't get paid for that time clock by that time clock, for the fact that if I run out of hours somewhere and I come in, I don't get paid. It's not even recorded. I haven't been paid in 10 years, as well as 400 other drivers. Who knows how long they've been there, maybe 25 years. They haven't been paid. They haven't been paid the difference in miles, and they haven't been paid the delay. They pay, they don't pay. Okay, that's the driver's room data machine clock. It's got nothing to do with the onboard automatic recording device, which you get paid by the trip sheet, and you got to turn it in order to get paid. If you don't get paid. Now, the data machine in the driver's room is not the case. So I'm innocent. I'm innocent beyond a reasonable doubt. It's got nothing to do with policy. The policy, they violated their own policy. They instruct us to follow the regulation, etc., and that's what I did. Now, me and 400 other drivers do the same thing, and I've been doing it for the last going on 10 years. Now, I don't see where I did anything wrong, and I haven't been corrected in 10 years, and haven't been corrected now. And the end doesn't justify the means. So they need to pay me from December 7, 2010. Beyond a reasonable doubt. There's no doubt about it. I follow company policy. I follow regulation. It's not my fault that Mike Sadler got his wires crossed. He should have never posted that document. And the dispatcher should have never falsified or altered my time on my onboard automatic recording device. That was a no-no. Now, I'm only standing up for my rights. So, if I didn't do anything wrong and I'm innocent, do I have a right to stand up for my rights? And should I be returned to work? According to the contract, I should be returned to work. Because they didn't prove anything, they didn't establish anything, they didn't do anything. In fact, they did everything the opposite. Okay? So, and I stand to be corrected. I do. Okay, you can show me where it says we're not under DOT regulation, we're not under their wing for 24 hours. You need to show me that, because if you don't, we can't be on two policies at once. God, there's no such thing. I've been driving a truck for 50 years. I ain't never heard of such a thing. So you can't be fired for punching in late when you're already on duty. And they got no right changing the time on my loss, because I lost 45 minutes in a day's pay. They don't have no right to do that. Two wrongs don't make a right. So me and my wife discussed that this morning, and that's the end of that. I'm getting carried away, because you know how it is when you write about something, you get excited, you know. And that's what I am. I'm getting excited, and I start rattling on, and it's just not fair. I should be working. I had 3 Christmases, and this is another sad Christmas. It's gonna be sad, but we're gonna be happy.
because we're a family, we're together. So it's not that bad, but it is bad. It is bad. But it's okay. It's okay. We'll have our day in court. So, anyway, for the record, James Williams, Transportation Manager, Tracy Distribution Center in Tracy, California, is in contempt of court. And he is also in violation of 132A because I had a notice of offer of work backed up by a QM report that says I can do my customary duties, and they took 15% off because of my permanent disability. They took the money and didn't complete their agreement by not working me for the 1 year, which I asked to be automatic retirement on my birthday next year. And the personnel department to be informed so that I'll be under the protection of the court until my birthday. That way they won't be kicking me off, putting me back on like they did in 2009 and not pay my pension, my back pay, or anything else. And I had a full duty release to go to work. And that's not a controversy, and that's not an issue at this point. Because I'm only bringing it up because I need a court order stating that I should get paid my 14 hours a day, 7 days a week, because of the fact of what happened in 2009. So I'm not asking for back pay for 2009 or the pension benefits or anything else. But I am asking for December 7, 2010 because an injustice occurred. An injustice occurred. And they're in contempt of court, and they're in violation of 132A, and they broke state law, labor law, and they violated the contract, and they violated their own company policy. Now, I don't know for sure about that company policy. I stand to be corrected. But it seems to me that Mike Sadler didn't follow his own standards. So, and James Williams, Transportation Manager, is right along with him. So, it's their responsibility, and we'll let the judge decide that. And I have a witness and documents. So, end of story.
Today is Sunday, December 16, 2012, and I'm going to add this to the last statement I made. It's just a short statement regarding did I try to obtain employment? I did try to obtain employment in December when I was off work because of the fact that the discharge was denied on December 17, 2010. And the fact that they didn't establish beyond a reasonable doubt that I was guilty because they didn't prove their accusations. They didn't send in documents, photos, etc., by December 25th, 2010. They violated the time limits, okay? Null and void, final and binding, not within 10 days. 20 days or 30 days. They didn't do anything, as we all know that. Okay, so they didn't put me, they refused to put me back to work, and they didn't honor the notice of offer of work, which you already know that, which we already know all that. So my point being is that I was unable to obtain employment because of the fact that the dispatcher falsified my logs, and I didn't have the proper hours to report to the new employer how many hours I had left and if I had enough hours to work. And on top of that, that wasn't bad enough. I had a notice of offer of work that they didn't honor, which I had a permanent disability, and they didn't honor it. Okay, they didn't work me. They took the money, but they didn't work me. So I was unable to obtain employment because of the fact that I had a notice of discharge, a letter from the union attorney on December 16th, and it was sent to the union on December 17th, email or fax, and the discharge letter, the reply was sent by Mr. Nicewanger to James Williams, Transportation Manager, in Tracy Distribution Center in California. Okay, and he didn't honor it. He didn't do anything. Okay, so on that fact, the fact that they accused me of falsifying documents and didn't give me all my logs to show the proper hours I had so that I can obtain employment, I was unable to obtain employment. I called Northern Transportation. They had a job there, and I was going to get hired until I told them what happened at Safeway, and that I worked there almost 10 years. And they just flat out sent me home. And they accused me of attempt to falsify documents, which we all know is not possible. So I was unable to obtain employment, and I was instructed by Northern Transport from the supervisor that I need to go back to Safeway and clear myself. He's unable to hire me, and he suggested that I should do that as soon as possible for the fact that I won't be able to obtain employment anywhere because of falsification, and I don't have all my hours and all my logs for the last 7 days. So I'd just like to note that. End of story. And again, today is December 16, 2012, and it's the third Christmas. And they still haven't called me to report to work, and I'm waiting for registered mail or a phone call. End of notation. And I hope Judge Grill considers this in getting a court order for back pay and benefits from December 7, 2010 until I report to work. All back pay and benefits, and I need my lifetime medical, so I need to be returned to work. So, and I claim life is not fair. I invoke double standards. And that's it. I hope Judge Grill considers this and go with God. Okay, today is December 7th, Friday at 10 o'clock in the morning. I'm going to add this to the statement I just made. Okay, and this is Julio Zamora, 1385 El Camino, Los Banos, California. As we all know, I claim double standards. Life is not fair. A double standard is the application of different sets of principles for similar situations or to different people in the same situation. A double standard may take the form of an instance in which certain concepts, often, for example, a word, phrase, social norm, or rule, are perceived as acceptable to be applied by one group of people, but are considered unacceptable, taboo, when applied by another group. The concept of double standards has long been applied, as early as 1872, to different moral structures on men versus women. A double standard, thus, can be described as a sort of bias, morality unfair suspension towards a certain group of the principles that all are equal in their freedoms. Such double standards are seen as unjustified because they violate a basic maxim of modern legal jurisprudence, that all parties should stand equal before the law. Double standards also violate the principle of justice, known as impartiality, which is based on the assumption that the same standards should be applied to all people without regard to subjective bias or favoritism based on social class, rank, ethnicity, gender, religion, sexual orientation, age, or other distinctions. A double standard violates this principle by holding different people accountable according to different standards. The phrase, life is not fair, may be invoked in order to mollify concerns over double standards. There is a distinction to be made between double standards and hypocrisy, which implies the stated or presumed acceptance of a single standard a person claims to hold himself or herself accountable to, but which in practice may be disregarded. Being hypocritical to the double standards is then a positive example of hypocrisy as well. I'd like to note that for the record, and I'd like to claim double standards. Life is not fair. This is Julio Zamora, born September 7th, 1940. In the interest of justice, I ask that Judge Grill return me to work and hold this as asking him to consider this. Okay? So that's my notation, and go with God. Okay, today is Thursday, December 20th. 5 more days to Christmas. This is a statement I'm going to add, that I invoke double standards. Life is not fair. Why? Because the dispatcher on December 6th and December 7th falsified my logs, and he threw my timesheet or trip sheet in the garbage can, and I didn't get paid. He falsified documents, and he broke the DOT regulation federal law, or whatever the federal government, DOT is the federal government. Whatever, he falsified. That's a serious offense, and there's no doubt about it. The fact is I'm innocent, and that guy is working. He's been working, okay? He's enjoying his holidays, his Christmas, he's getting paid, and he falsified documents. Okay, I'm sitting here waiting for a phone call or registered mail. And I'm innocent. I didn't do anything wrong. I should be working. They should have called me up to report to work, and no doubt about it, or registered mail. The union should have took action and put me back to work. Okay? So in the interest of justice, I'm asking Judge Grill to return me to work and give me all my back pay and benefits due to the fact that this man who falsified my documents on December 6th and December 7th, okay, and is still working. He's still working, and I'm not. And I've got kids in the university, okay? I mean, we don't need to go there. The fact is the man broke the law. He falsified. All right, and I'm unable to obtain employment because of his actions. So, and I lost my lifetime medical that I paid for out of my pocket because of his actions. Okay, and he's working again. I'm repeating myself because I'm partly deaf. So, that being said, I'm asking Judge Grill to please consider this. The fact that this man is working and I'm not, and I'm innocent. Did I get my all back pay and benefits from December 7, 2010, like I said earlier in the recording. So in the interest of justice, I invoke double standards. Life is not fair. In the interest of justice, for Judge Grill to consider this. And the notation. Okay, today is Tuesday, December 18, 2012. On December 1st, 2010, I received a notice of offer of work, which they held up for 2 months, followed with a Q&A report saying I can do my customary duties, and that I have a permanent disability, and that I'm allowed prescription drug, and that they're going to take 15% out because I have a permanent disability. On December 3rd, 2010, I went to work. On the 5th day of work, I was flat out sent home because I received a notice of offer of work on December 1st, 2010. Today is Tuesday, December 18, 2012. I, Julio Zamora, invoke double standards. Life is not fair. This is Julio Zamora. I would like to invoke double standards. Life is not fair, and for Judge Grill to consider this. Thank you so much. Go with God. Today is Tuesday, December 18, 2012. I, Julio Zamora, invoke double standards. Life is not fair. This is Julio Zamora. I would like to invoke double standards. Life is not fair, and for Judgeville to consider this. Thank you so much. Go with God.